When the government, in the form of the police, damages your property, who pays for it? In the case of VIcki Baker versus City of McKinney, Texas, the police had to damage her property to apprehend a fleeing felon. However, when the city refused to pay for the damages, Ms. Baker sued. The district court found for her, but the circuit court overturned. When she asked the Supreme Court to review, they declined certiorari. Two justices expressed concern with the prospect of government damaging homes without paying compensation. So we'll look at this case next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach a rising generation to be free. I'm glad you could join me today. It was an interesting case, this Baker versus City of McKinney. But there's a lot more behind it than simply the decisions of a couple of justices. It's the fundamental question of who's responsible and who should pay the price. Now, if you want to find out more about what we're doing here, you can always head to the website, constitutionstudy.com, and I'll talk more about the website and other things later. But for now, let's get into this case, Baker versus City of McKinney, Texas. Imagine the police have to enter your home, and in doing so, they damage your property. Who pays for those damages? Your insurance? The police? That was a controversy brought to the district court. Now, before we dig into that, though, let's look at the background. On July 25th, 2020, Wesley Little kidnapped a 15-year-old girl. After a high-speed car chase, Mr. Little entered the home of VIcki Baker. Now, Mr. Little had worked there previously as a handyman. Ms. Baker's daughter was there, and after letting Mr. Little into the house, she called police. When McKinney police arrived, they set up a perimeter around Ms. Baker's home. Eventually, Mr. Little released the girl, who exited the house, and told police that Mr. Little was armed, high on methamphetamine, and hiding in the attic. Little told the police that he was not going back to prison, that he knew he was going to die and planned to shoot it out with the cops. The police tried to drive Mr. Little out of the house with tear gas. When that didn't work, officers detonated explosives to break down doors and used a tank-like vehicle to bulldoze the backyard fence. However, by the time police gained entry, Mr. Little had taken his own life. While the actions taken by the police were necessary and proper, they did leave approximately $50,000 in damages. From Justice Sotomayor's statement, we read, "The explosions left Baker's dog permanently blind and deaf. The toxic gas that permeated the house required the services of a hazmat remediation team. Appliances and fabrics were irreparable. Ceiling fans, plumbing, floors, hard surfaces, as well as carpet and bricks need to be replaced, in addition to the windows, blinds, fence, front door, and garage door. Essentially, all of the personal property in the house was destroyed, including an antique doll collection left to Baker by her mother." Now, you may think that this damage would be covered by homeowners insurance, but it's not. Moreover, it appears that homeowners insurance policies generally do not cover damages caused by government. From Justice Sotomayor's statement, Baker, who bore no responsibility for what had occurred at her home, then filed a claim for property damages with the city. The city denied the claim in its entirety. Baker thereafter sued the city, alleging a violation of the Takings Clause. At the summary judgment stage, the district court held that the city's destruction of Baker's property was a compensatable takings under the Fifth Amendment. This is based on Baker v. McKinney. Following trial, a jury awarded Baker nearly $60,000 in damages. So far, things seem okay for Ms. Baker, but that was about to change. When the city appealed the district court's decision, the Fifth Circuit reversed. But why? On appeal, the Fifth Circuit reversed. The court declined to adopt the city's broad assertion that the Takings Clause never requires compensation when a government agent destroys property pursuant to its police power. Such a broad categorical rule, the Fifth Circuit reasoned, was at odds with its own precedent and this court's Takings Clause jurisprudence. The circuit court didn't completely agree with the city's position that the takings clause never requires the government to compensate property owners for damages done while exercising their police powers. The Fifth Circuit thought that the position was at odds with their precedent on the takings clause. Instead, the Fifth Circuit adopted a narrower rule that it understood to be compelled by history and precedent. The takings clause does not require compensation for damaged property when it is objectively necessary for officers to damage a property in an act of emergency to prevent imminent harm to persons. Interesting. The Fifth Circuit did not come to this decision because of the Constitution, but because of what it had decided before. So let's look at the takings clause and see if the Fifth Circuit's precedent is constitutionally sound. So we find the takings clause in the Fifth Amendment to the Constitution. Nor shall private property be taken for public use without just compensation. Now, from this language, we find two criteria for the takings clause to be invoked. Private property must be taken, and it must be for public use. Was Ms. Baker's property taken? Not exactly. Her home wasn't taken, neither was anything inside taken. Her home was damaged by police. Was her home acquired for public use? Again, not exactly. The damage done to her home was done when the police were exercising their legitimate powers, but that isn't a taking for public use. An argument could be made that the police took control of her home temporarily for the purpose of exercising their public duty to apprehend a fleeing felon, but that does not meet the history or language of the takings clause. However, there's another clause in the Fifth Amendment that may apply, the due process clause. No person shall be deprived of life, liberty, or property without due process of law. Ms. Baker has been deprived of her property by having it damaged and therefore devalued without due process of law. Furthermore, under Texas Penal Code, Title 7, Chapter 28, the actions of the police were criminal mischief. Section 28.03 defines criminal mischief as a person commits an offense if without the effective consent of the owner, he intentionally or knowingly damages or destroys the tangible property of the owner. In fact, the crime in this case is a third-degree felony. Later in that section we read, except as provided by subsections F and H, an offense under this section is a felony of the third degree if the amount of the pecuniary loss is $30,000 or more but less than $150,000. Does this mean that the officer should be charged with criminal mischief? No. It's obvious that the police were acting within the city's police powers. Because the parties agree that McKinney's police actions were objectively necessary, the Fifth Circuit concluded that Baker was not entitled to compensation. Baker now petitions for certiorari and asks this court to reverse the Fifth Circuit's judgment. While I agree with the Fifth Circuit's decision that this is not a compensatable action under the Fifth Amendment's takings clause, that doesn't mean the city of McKinney should be off the hook. Ms. Baker, however, asked the Supreme Court to hear the case known as a petition for certiorari. While the court denied this petition without comment, Justice Sotomayor wrote a statement joined by Justice Gorsuch with her position on the case. The court's denial of certiorari expresses no view on the merits of the decision below. I write separately to emphasize that the petitioner raised a serious question, whether the takings clause permits the government to destroy private property without paying just compensation as long as the government had no choice but to do so. Justice Sotomayor makes a key point regarding government employees destroying private property without just compensation. Had McKinney razed Baker's home to build a public park, Baker undoubtedly would have been entitled to compensation. Here, the McKinney police destroyed Baker's home for a different public benefit, to protect local residents and themselves from an armed and dangerous individual. Under the Fifth Circuit decision, Baker alone must bear the cost of that public benefit. Justice Sotomayor is correct in her statement, but appears not to realize that she just shot down her own position regarding the takings clause. See, if McKinney had taken Ms. Baker's home to build a park, that would meet the takings clause. Property was taken for public use. However, what happened to Ms. Baker, as the justice points out, the police destroyed, they damaged Baker's home for a public benefit, not for public use. In support of her position, Justice Sotomayor points to the case Armstrong v. United States, where she finds, the Fifth Amendment's guarantee that private property shall not be taken for a public use without just compensation was designed to bar government from forcing some people alone to bear public burdens which, in all fairness and justice, should be borne by the public as a whole. However, both Justices Black from Armstrong and Sotomayor from Baker are rewriting the Constitution to get it to say that what they want it to say. Takings include damage, and public use includes public benefit. Now, all parties agree that the actions of McKinney police were objectively necessary and therefore justified. And while the Supreme Court did not explain why they refused to hear the case, I do think there is a just solution to this case. The city of McKinney has deprived Ms. Baker of her property. That is not disputed. Ms. Baker bore no responsibility for what happened to her home. That too is plainly obvious. The city denied Ms. Baker's claim, though the reasoning behind that decision was not included in Justice Sotomayor's statement. But did Ms. Baker receive due process when the city of McKinney destroyed her property? Due process is defined as an established course for judicial proceedings or other government activities designed to safeguard the legal rights of the individual. I would say no. The city of McKinney deprived her of her property using government activities that were designed to safeguard the legal rights of the public at large, but not of the individual. Therefore, the only just decision I can think of would have been to fine for Ms. Baker and have the city of McKinney pay for the damages to her home, not on the grounds of the takings clause, but the due process clause. This is another example of why it's so important that both the attorneys and judges in a case be familiar with the text of the Constitution rather than just the commentary about it, often referred to as constitutional law. Would the judges in any of these courts have looked at this case differently if it had been presented as a deprivation of property without due process rather than a takings? Remember, the judges in these cases are deciding based on the facts of the case. Bad facts make bad decisions. So I thought that was an interesting case, an interesting question. If the police damage your property while exercising their duty, who pays for the damages? You or the city that, or county that the police represented? I think Ms. Baker has a claim under the Fifth Amendment's due process clause, not the takings clause. Again, I don't know if that would have made it different in arguments, but to me, that's the question. Is as a due process issue, yes, she has been deprived of property without due process of law, and I don't think the city should get away with it. I'm not saying what the city did was wrong. There's a lot of things that we pay for that are not wrong, but when you do damage, you owe people compensation. Now, I'm curious what you think. Please comment. Let me know. What do you think about this case? What do you think about the city of McKinney? Or what do you think about the Supreme Court in not even hearing the case without even bothering to say why? That's another part of the case that I find fairly interesting. Why did the court decide not to take the case? Did they not think it was a takings case? We'll never know because they never actually said why. Again, it shows the importance of understanding the Constitution so that if you're in a situation where you're working with an attorney on a case, you can help educate the attorney about the language of the Constitution, since odds are they didn't actually study the Constitution in law school. They studied the opinion of judges known as constitutional law. Now, if you want to learn more, there are a lot of great places. You can always head to the website, constitutionstudy.com. Head to the shop and find my books. I've written a daily devotional for reading the Constitution. I've also written my clause-by-clause study of the entire Declaration of Independence and the Constitution. Both are available there, constitutionstudy.com/shop. I also found this neat little course called The Miracle of America. It's a bit of a history between the colonies and through the drafting of the Constitution. I thought it was very interesting. So much so that I made a deal with the publisher to get you one lesson absolutely free, so you can try it before you buy it. So go to constitutionstudy.com/1776 study guide. You'll be taken to a custom landing page where you can not only read about the course, but you can enroll for a free lesson on God's natural law. Whether you take the course as a whole or not, take that lesson. I think you'll find it quite educational. Of course, once you do, I think you'll want to take the entire course for just $17.76. So again, the URL is constitutionstudy.com/1776 study guide. It's the numerals 1776 study guide to go to the custom landing page and enroll for your free lesson. I also hope you'll support organizations like Patriot Mobile. The the country's only Christian conservative wireless provider. I've been a customer of theirs for years. They've got great customer service. They've got great 4G and 5G coverage. And they're just a nice company to deal with because I know when I pay my bill, they're not using those proceeds to fund organizations trying to destroy our rights. They're funding organizations like the Susan B. Anthony List, NRA, Folds of Honor, even the Constitution Study that are helping to protect and defend our rights. Just go to patriotmobile.com/Constitution, find a plan that works for you. And if you do what you do, be sure to use the code Constitution at checkout to get free activation. You do that, you're not only getting great cell phone coverage, you're also supporting the Constitution Study. So that website again is patriotmobile.com/Constitution. And don't forget to use the code Constitution at checkout to get free activation. Now, whether you support the work that we do here, whether you pay for my books or sign up with one of the affiliates, do me a favor. If you liked this program, if you liked what we covered, share it. Let other people know about the Constitution Study and the work that we're doing here. If you have a question or a topic you would like me to go into, let me know. Go to constitutionstudy.com/questions, and you can ask your question or just ask that I cover a certain topic. Most of all, please come back and join us here. Hey, maybe bring a friend or two the next time we meet for the Constitution Study.